Hey folks, welcome to Roll of Law. Hopefully everyone can hear me. Hopefully everyone's having a good night. So yeah, this is one that if you are a creator who's been really hoping that this would be, that the orc would be the answer to all your problems, then you might want to sit down for and maybe pour yourself a drink. I've got a drink right here. And if you're wondering what the ORC is, this is Paizo's Open RPG Creative License. So they call it the ORC license because, hey, that's kind of funny. Now, this is currently out on the, this was put out on April 7th. And I haven't yet written a thing to sort of give my comments on it. But I do, maybe I should jump on their Discord and just see if I can, throw up a link to the ORC license. Because, yeah, this is worthwhile. So, yeah, I have some concerns about this one. That's what I'm going to say on this one. I'm just throwing that up on the ORC general discussion there. We'll see if I get banned here, but I'm going to start here by kind of talking about what their goals are, because their goals are really good. Their goals are things that I think are laudable and should be supported. So what they're looking for, and this, I'm just going to read off their sort of goals that they've got posted. So one, create a system neutral open gaming license that provides a legal framework for sharing game rule mechanics content between publishers, like that. Next is provide game designers and publishers clarity on how to use game mechanics published under the license without having to pay lawyers to research or defend that use. I also like that. I mean, I'm a lawyer, and one of my goals is to spend as little money hiring lawyers as I can. So I don't want to be in a situation where I have to hire a specialist in order to just, do the stuff. So next is establish a community of open game publishers to better share best practices, advice, and resources. And 4, when the license is complete, find an appropriate independent nonprofit home for the new license, unaffiliated with the shifting self-interest of any company involved in the tabletop publishing business, which is good, because the last thing you want is, say, for Wizards of the Coast to get purchased and then decide that they want to change the rules. So that's kind of the basics of what they're looking for. Now, what we're looking at here is it's a draft. It's the first draft, in fact. And, that's worth keeping in mind. This is something that may well change. So let's start by looking over at they've got what they call the ORC Axe. And I mean, the puns are getting a little too on the nose, but the Axe is the answers and explanations for the ORC license. It's the FAQ. So we'll start with the FAQ, and then we'll get into the legal nitty gritty, and because the legal nitty gritty is going to be, yeah. So let's start with this, and I'll just pull this up on the screen here. The joys of technology. Here we go. And I see somebody saying, so Wizards of the Coast did not cave. They did, but that doesn't mean we don't need something else. All right, so we've got the, this is the ORC Axe. All right, so it starts off with, how does the ORC license work? And it's a license that can be used by anyone. And this is important because this means that it's an actual open license. Whereas like the previous drafts of what they were going to do with the OGL were making it not an open license because you had to actually go through permission. So this is just, if you put the ORC notice in your work, then your protectable game mechanics plus any product identity that you expressly dedicate to the gaming community are open for others to use under the ORC license. And all you have to do is put an ORC notice in your product and you're done. And they give you a little sample ORC notice, right? So this is just something that's real quick and easy. And yes, acts for answers and explanations, that's a stretch. They're really reaching for the pun there. And I see, unlike the Wizards of the Coast draft, nobody's being pressured to sign this right this minute. Absolutely. And I'm going to say you shouldn't yet. Like, this is not something to put in your material quite at this point. So why did you create the ORC? And they're saying role-playing games do an amazing job of infusing protectable creative descriptions with unprotectable game rules in a way that is challenging to separate legally. What they're talking about here is that game rules, the fundamental sort of underpinnings, are not protectable. They're not something that copyright can cover. They might be something that patent could cover, except usually they're not. But the problem is that when you actually want to use those, often you need the text, which might be protected. So if I want to use, say, the fireball spell, well, I might need to actually go into Fireball. And Fireball's not that hard because it's fairly simple. If you start getting into something a little more complicated, like, say, Simulacrum, that spell is complicated and the specific language matters. You get into arguments at the table over what you can and can't do with a spell. Or, if you want to get really difficult, a power like Minor Conjuration out of, 5th edition, where even right now, as we speak, there are arguments going on online and off about what exactly that power does, and they hinge on exact turns of phrasing. So this is important. This is kind of the problem. So this complexity has had a stifling effect on creativity in our industry. We created the ORC license to be a tool that gives you the right to use an ORC licenser's protectable game mechanics easily and confidently. And it grants users a license to the copyright protection that exists in this complex form of intellectual property without publishers having to hire lawyers to separate that which is copyright protected from that which isn't, which is good because we charge a boatload of money. It's super expensive. Try not to hire us. They want to give comfort, confidence, and certainty, which, again, is excellent, right? I want to see that lots of people can just make stuff. For every game that I play, I want to see a community that is able to generate content because maybe I don't have time to do it. And there's a really great wealth of content out there where you can go out and pick stuff up and use it. And it's fantastic. They also note the ORC license substantially reduces the threat of litigation regarding these matters, which could easily bankrupt a small publisher who is in the right and operating in good faith. This is another real problem that you get, which is that even though you're right, you could go out of business just trying to fight one of these lawsuits. And that's a real problem. It's this. So one of their goals is explicitly to reduce the issue that I mentioned when we were talking about the OGL issues, where, sure, you might be right, but at the end of the day, they have more money than you and they can just legally battle you into oblivion. That's not something we want to see. All right. Why is the license so complicated? Well, we're going to try to make it simpler here. I'm going to try to simplify it as much as I can, but we're going to go through and get technical at the same time. That's kind of what lawyers do. So we opted for simplicity wherever possible, but they have to choose precision where there's a choice between the two of those things. As a lawyer, I will tell you that's the right call. You want a document that's going to hold up and not a document that is going to require a ton of litigation to sort out, because otherwise you're back at the initial problem, right? So who controls the ORC license? No one. They're specifically making it so there's no controller. Nobody can update it. Nobody can fix it, which means if this license is broken, there will be no way to fix it. So they got to get it right the first time. This is why they're having these draft discussions, and I think that is fantastic. Can it be updated, revoked, amended? Can you pull your stuff out once you've licensed it? The answer to that is all no. So no to all of that. Why did Azora register copyright in the ORC license? Well, they basically just say that lets them put a copy on file with the U.S. Library of Congress. So Great. But they specifically say that they will never enforce copyright in the ORC license. You can't say that that is or isn't the case, but I feel like they would not be able to enforce copyright in the ORC license just because it's a legal document aimed at the world. I don't think that's something that they would be able to do. Who enforces it? They say all the upstream licensors can sue you to enforce the license, but their remedy is limited to bringing you into compliance with the license. We'll talk about that a little bit in terms of remedies. They note, we have intentionally not specified a jurisdiction, which means that anyone suing to enforce the ORC will need to bring that dispute in your jurisdiction. This is a great thing, and I'm just going to mention, they say this is a tool intended to discourage litigation. It also provides home field advantage to whoever is defending. And the reason why that's good is that whenever you sign a contract with some company, they will include a choice of laws provision. I just finished going over and talking a little bit about the contract that Ethan Klein had with BBTV. And that one includes a choice of laws provision that says that if you want to fight that, it's got to be in Vancouver, British Columbia, because BBTV is in Vancouver, British Columbia. And that means that you get to use your local law, which you're familiar with. You get to hire a lawyer who is local, which makes it a lot easier to meet with them. I mean, it's gotten easier to remotely meet with your lawyers in the age of, Zoom and so forth. But it's still nice to be able to walk into their office. Whereas if you're remote, Ethan Klein was mentioning on one of his streams, he was going to have to hire a lawyer in Vancouver. And that means that, he's got to either fly out there if he wants a personal meeting, or he's going to have to do a lot of stuff on Zoom. So that's an important thing. It also tends to mean it's going to be more expensive to sue somebody who's far away. And this could also mean that some of the people out there might be very difficult to sue. For instance, it's one thing if I've got to sue you in California. I don't mind California. It might be a nice place to visit. But let's say they're located in Uzbekistan or, I don't know, Ukraine. I feel like Ukraine is not a great place to visit right now. There might be a little more explosives in the air than you're familiar with or that you like. So this is potentially a problem there. Can I pull my stuff out of the ORC license once I put it in there? The answer to that is no. So you got to be real sure before you put something in the ORC license. They note, can I use it on a board game? Yes, you can use it for any sort of game you can imagine. You might want to think about whether that's something you want to do or not. And what about digital rights? Digital rights are fully included. It doesn't specify anything about format, so it's not format specifically. The license lasts forever. Cool. Are there SRDs? They say they'll probably be the equivalent to these, but the ORC license is designed to not require them. And I agree with this conclusion that the ORC license doesn't really need an SRD, but an SRD might be a convenient warehouse for the stuff that is allowable. So, and they note someone could create a system resource document that contains what they believe is strictly a game mechanic system. So in theory, you could make your own SRD for an ORC licensed game. Let's say they decided to license Pathfinder, 7, like several editions down the road, is under the ORC license. Well, I could theoretically pull all of the sort of ORC available content, put that into a document, and share it with the world. I could even sell it if I wanted, but we'll talk about whether or not I could actually expect to make any money for that effort. So we'll talk about that as we go. The ORC license uses a definition system that defines what is licensed ORC content and what is unlicensed proprietary product identity and lifts that administrative burden from publishers. And so they say, we believe these definitions are sufficiently robust to allow game designers, publishers, and lawyers acting in good faith to come to a common understanding about what is licensed without the administrative friction and potential for failure of coming up with an SRD for each product. So, yeah. So I just got the license to build an RPG on the newest Hollywood blockbuster. Can I build this on the ORC license? And they say yes. There's some asterisks to that because you'd have to actually negotiate with the publisher and so forth. Can I say which primary game my product is built on? Absolutely. The trademark legal doctrine of nominative fair use holds that you can say that your product is compatible with another product. This is important. Nominative fair use basically means that you can't have a trademark and then ban people from referring to your product. And especially this is designed to make sure that trademarks are not used in an anti-competitive way. So as an example, let us say that I make cars, right? And I would really like to be the sole manufacturer of parts for this car. But the law actually says that there should be competition in that. And that if somebody else wants to make a muffler that fits in my car and they're not using any patented technologies that, they're not allowed to use, they should be able to make that muffler, but not just make the muffler, but also tell people that it's compatible with this car. Like this is compatible with the Honda Civic, even though you don't make Honda Civics, right? So that is that's important, although it's a tricky area of law. It is easy to make mistakes here because if you accidentally make it seem like you are the Honda, that you are Honda, or that you have, the control over the Civic trademark, then that's a problem. I see you can't ban everyone from using words in your product, but didn't Monster Energy C&D a bunch of unrelated products mentioning Monster internationally? Monster is, they're actually super litigious, and they litigate over a bunch of stuff that I think they don't have a great, aspect. SRD 5.1 under OGL 1.0, he says that Dungeons and Dragons is part of their product identity, which is sketch. I agree. The OGL 1.0a identifies some stuff as product identity that I think is a bit of an issue. And in fact, I think that I've mentioned that the OGL basically seems to give themselves extra rights that that otherwise they wouldn't have had. It basically protects things that otherwise might not have been protectable once you agree to it, which is a problem. All right, now we're going to get into something that that connects to where I think the problem is with this particular document. So why not Creative Commons? All right, they have two entries here. We tried hard to make a Creative Commons license work, but ran into one of two unresolvable problems. So the first is with Creative Commons by SA, which is the attribution and share alike license, which means that for everything that you get, you have to both attribute it to the original person. So you have to give credit. That's what the attribution part is. And share alike means that you have to share it under exactly the same terms. So under which the initial licensor can limit their licensed material to the ORC content. Unfortunately, the share-alike provision requires the downstream community to share their entire work. So you have to share everything. We would have loved to make that work, but it would have violated the terms of the license to limit the downstream community to licensing out only their ORC content. So basically the problem is that if you use that, then you have to share everything, which is going to be a problem. And then they say, Wizards used Creative Commons Attribution 4.0, which gives everyone the right to use the contents of the SRD they designated. This was a wonderful assurance for the gaming community that 5e could confidently be used forever. I agree with that. Unfortunately, when another company builds on their SRD, their innovations are trapped in their product and not automatically relicensed to the gaming community. This effectively kills the virtuous circle that open source communities are built on. Now we're going to talk about this and whether or not this is actually a good thing for content creators. Because what they're saying is they want to create this virtuous circle, but this virtuous circle might be a real problem if you are trying to make third-party content. And I'm going to use an example. I actually downloaded something off DM's Guild, just so I could show you an example of how this will go wrong in practice. All right, so let's look at the draft, and they've got it marked This one is watermarked all to heck, so that is a good thing. So definitions. Everybody gets bored at definitions, but they're important. Cases are won and lost on definitions. The video I just did about Ethan Klein and his difficulties with, BBTV hinged on definitions. So, yeah. Product identity means trademarks, trade dress, and non-functional and creative expressions that are not essential to or can be varied without altering the ideas or methods of operation of a game, including works of visual art, music and sound design, and clearly expressed and sufficiently delineated characters, character organizations, dialogue, setting, locations, worlds, plots, or storylines, including proper nouns and the adjectives, names, and titles derived from proper nouns. So your characters, your settings, music, pictures that you include, all of these things are things that you can, that are going to remain as product identity. The term product identity shall in no event include elements that have been previously designated as ORC content. So you can't use product identity to un-ORC ORC content, I guess is the way to put that. Adapted ORC content that are the exclusive property of one or more third parties or that are in the public domain. So you can't claim product identity over, I don't know, Sherlock Holmes or Jesus, Robin Hood, any of those sort of old characters. You also can't claim product identity over something that belongs to someone else. So you can't, for instance, put John Wick in there and say that's my product identity, unless you also happen to own John Wick, in which case you probably have the lawyers to hire to review this yourself. So ORC content means, one, any material that would otherwise constitute product identity, but that has been expressly identified as ORC content by a licensor, which means that if you want, you can ORC content anything that is in there. So if you do if you like your setting and you want your entire setting, or you've made a character and you want that under the license, you can do that. That's no problem. So good. And two, those expressions of ideas and methods of operation of a game that are comprised of systems, procedures, processes, rules, laws, instructions, heuristics, routines, functional elements, commands, structures, principles, methodologies, operations, devices, and concepts of play. Whew, somebody found the thesaurus. And the limitations, restraints, constraints, allowances, and affordances inherent in gameplay, including expressions describing the function of or providing instructions as to the following. Now, this is not an exhaustive list. This is including, and this is also going to be useful for interpretation purposes, because when we're trying to determine what that big, long list of things means, well, we got some examples of what's included. So these are things that are specifically included, but these terms are intended very much to be very broad and to apply to a lot of things. So one, creation and play of player and non-player characters, including statistics, attributes, stat blocks, traits, classes, jobs, alignments, professions, proficiencies, abilities, spells, skills, actions, reactions, interactions, resources, and equipment. Now, keep in mind when we are looking at these names, different games may call these different things. But I think that a court put into the position of interpreting this is going to, for instance, even though you may not call it skills, you might call it talents or something like that. They'll say, listen, that is specifically intended to be included. So this is a fairly broad set of categories. Systems and classifications applicable to gameplay, including alignments, backgrounds, classes, experience points, levels and leveling up, encounters, combat, initiative, and turn order, movement, monster statistics, creature types, traps, conditions, buffs and debuffs, terrain types, challenge ratings, difficulty classes, skill checks, saving throws, resting and resource management, classification of magic systems, spell and ability effects, looting, items and equipment, diplomacy systems, dialogue options, and outcome determination. Whew, that's a lot of stuff, right? But we're gonna look at a specific example here as to what things might happen. And I see somebody saying that they're trying to limit gameplay. This is actually all stuff that becomes part of the ORC license. So all of this is stuff that becomes available to the public. So gameplay is not really limited here in terms of what you can copy. So that is important. Methods of determining success, failure, or outcome, and any expressions of such method or of such successes, failures, or outcomes. So this is, any sort of dice rolling, any sort of, how you, this is the meat of how the game works. So next, methods and mediums by which players play the game, including dice rolling, random number generation, coin flipping, card drawing and play, applying modifiers to results of chance, creating or filling in character sheets, moving and interacting with tokens or figurines, drawing maps and illustrations, speaking, messaging, acting, pantomime, writing notes, asking questions, and making statements. I am pretty sure pantomime is in here specifically as a jokey reference to the OGL debacle, and I'm here for that. Cheers to that little bit of snark. All right. It's going to be that, the role-playing game community is going to have a huge set of contractual terms all based around pantomime. Fantastic. All right. So for the avoidance of doubt, the term ORC content expressly excludes product identity absent and to the limited extent expressly designated as such by the licensor in the notice published pursuant to Article 3. So this is basically saying that your product identity is still protected. It is still covered unless you specifically say otherwise. Cool. Now, here's where we're going to get into some, fun elements. So adapted ORC content means derivative works based on the ORC content that you create to the limited extent that such derivative works would otherwise constitute ORC content. Adapted ORC content expressly excludes works that would constitute product identity. So if you make a derivative work based on ORC content, then your stuff may itself be adapted ORC content. And adapted ORC content becomes basically ORC content, as we'll see. I see, although I can think of a couple of games that do use pantomime as part of their resolution systems, fair enough. That I'm not familiar of. Quest has at least one ability that's resolved via a game of charades. Interesting. What about sign language? Does it fall under pantomime? I think that would fall under messaging, or just making statements. All of those things would be fine. So, and yeah, talk about ASL, British Sign Language, all of that stuff. All right. Copyright and similar rights means copyright and / or similar rights closely related to copyright, including without limitation, performance, broadcast, sound recording, and sui generis database rights, without regard as to how the rights are labeled or categorized. In no event shall copyright and similar rights include trademark or patent rights. So this is important because this is a copyright license. It's not a trademark license. It's not a patent license. Now, there's another provision here. Effective technological measures mean those measures that, in the absence of proper authority, may not be circumvented under laws fulfilling obligations under Article 11 of the WIPO Copyright Treaty and / or other. So this is DRM, right? Digital rights management kind of things. And they're going to actually put limits on DRM. Dread Gazebo is asking, what is sui generis? Sui generis means of a type unique to itself. So basically, it's a thing that is unique. And so when we say that, so in Canada, we would say that Indigenous law is sui generis. And what that means is that Indigenous law applies principles that don't apply outside of Indigenous law. So it's one of a kind is how Claude Simeon put it, and it's a good way to put it. So sui generis database rights are a particular kind of rights that applies to databases, essentially. You're not going to have to worry about that too much for this, but yeah. So license rights means the rights granted to use subject to the terms and conditions of the ORC license, which are limited to all copyright and similar rights that apply to your use of the ORC content, and that the licensor has authority to license. Obviously, you can't get more rights than the person has the ability to give you. So that makes sense. Licensor, so any individual or entity granting rights under this ORC license. The sui generis database rights means rights other than copyright. We're talking about European government and legal protection of databases, etc., etc. Term means the term of the copyright. That's going to be important because copyright doesn't last forever, and they've actually got provisions for when your copyright expires, which is relevant. Use or used means to use material by any means or process that requires permission under the license rights, such as production, reproduction, creation of derivative works, public display, public performance, distribution, dissemination, communication, or importation, and to make material available to the public, including in ways that members of the public may access the material from a place and at a time individually chosen by them. So what that means is that using, when they say use, it means all of the stuff that would otherwise infringe copyright. Cool. And you or your means whoever it is that is exercising rights under the license. The reason why they're phrasing it as you or your instead of like licensee is for readability, which is good, right? They've said that they want to make sure that this is as simple and readable as possible, which I agree with. So primary grant to you. So this is what you get out of the ORC license. Subject to the terms and conditions of this ORC license, which there's going to be limits, right? For the term, licensor hereby grants you a worldwide, so everywhere on the planet. Worldwide will probably theoretically include space once we actually have space to worry about. But, I mean, I don't know. There's going to be a whole lot of contractual disputes once we get to Mars as to whether or not these worldwide licenses actually include, say, Mars or the space station. But that'll be fun. As much as I would love to, I just don't see myself getting into space law anytime soon. But maybe space law would be cool. So royalty free, which means you don't have to pay anything each time you do it. You can do it as many times as you want. You don't have to pay cash. Non-sub-licensable. This is important. I get the license. I can't license this on to Joe Schmo. Joe Schmo has to get the license from the original person, which they can do automatically. Non-exclusive, which means more than one person can use the ORC license content, which makes sense. It wouldn't be very useful if it was only like the first person to get there gets to, that would make no sense. So that would just not be useful. Irrevocable, which means that it can't be canceled. License to exercise the license rights in the ORC content to use the ORC content in whole or in part. Licensor hereby authorizes you to exercise the license rights in all media and formats, whether now known or hereafter created. So even if new technology comes up, then that doesn't necessarily, like, this will apply to that. Paladin Phil is saying there are space lawyers in space law currently. That doesn't surprise me. There's various, satellite issues and so forth. So, yeah, that's. I would like to talk to a space lawyer and just pick their brains sometime. All right, and to make technical modifications necessary to do so. So let's say I want to use your content in a video game. The technical modifications necessary to do so might allow me to translate your content, if it's ORC licensed, into something that works in that video game. Awesome. Licensor hereby waives and/or agrees not to assert any right or authority to forbid you from making technical modifications necessary to exercise the licensed rights, including technical modifications necessary to circumvent effective technological measures. This is a big one. So normally right now, if something is, if you lock something up with DRM, it can actually be an offense or something that somebody can sue over, depending on the jurisdiction, to break that DRM. And so this actually says that you will not sue or otherwise enforce any rights over your DRM, essentially, if somebody is breaking that DRM in order to exercise the ORC license. Which means, let's say you make a video game out of this. Well, you've probably got DRM, you've probably got various things that prevent people from just ripping the content out. And this says that you wouldn't be able to go after them for doing so. That becomes potentially interesting. I think that there might be some wrinkles down the road, but I will also say this will affect a tiny portion of people. And if this is really an issue that you are making a video game that, or something like that, and you expect that you need that DRM, you'd probably just work out a separate license for the content that isn't the ORC license. So grant of adapted ORC content by you. This is a nasty provision, and I'll explain why. You hereby receive an offer from the licensor to exercise the license rates on the express condition that you do and hereby grant to every recipient of the adapted ORC content an offer to exercise the license rights in the adapted ORC content under the terms and conditions hereof, pursuant to which such adapted ORC content shall be licensed as ORC content to such recipient. You may not offer or impose any additional or different terms or conditions on or apply any effective technological measures to the ORC content if doing so restricts exercise of the license right by any recipient of the ORC content. So any content that you make under the ORC license that would itself be ORCable, if I can use that turn of phrase, which that turn of phrase is giving me a headache. So, which would be ORCable. A, you can't apply any DRM to it, but B, all of the ORCable content has to itself be ORC licensed. And that could be a real big problem if you are an independent content creator. So I see Twincast is saying if you believe in DRM, you don't believe in open content to begin with. I am not a fan of DRM, but I am concerned over what this would do to a lot of content creators, which is that typically we don't want this to be this kind of contaminating license, if I can describe it like that, where you are required to share that content alike. Now, this is only share alike with respect to content that is kind of, within that sphere of ORCable stuff. So it doesn't apply to your product identity, but it applies to lots and lots of stuff. And this is potentially a big problem if you want to earn a buck off this. And lots of people are making content specifically because they want to sell the stuff, right? And I see, I think the usual term is viral license. Yes, this will infect your work is the problem. So database rights. So basically it applies the same thing to databases. Limitations. Nothing in this ORC license constitutes or may be construed as permission to assert or imply that you are or that your use of the ORC content is connected with, sponsored, endorsed, or granted official status by the licensor or others designated to receive attribution hereunder. So what that means is that if you, if Pathfinder 7 is licensed as ORC content, you can't say made with permission of Paizo. because otherwise Paizo will sue the crap out of you. Fair enough, right? They don't want that aspect. Moral rights, such as the right of integrity, are not licensed under this ORC license, nor are publicity, privacy, or any other similar personality rights. However, to the extent possible, licensor waives and/or agrees not to assert any such rights held by the licensor to the limited extent necessary to allow you to exercise the license rights, but not otherwise. This is complicated, but it basically means that I can't use somebody else's name or violate moral rights, which moral rights are complicated, but they typically involve things where you can't like chop up somebody else's work. So let's say I buy a Banksy and then I paint it to make it look like a corporate endorsement. That would be a violation of Banksy's moral rights. Although I don't even actually know if Banksy is operating in a jurisdiction where moral rights exist. In Canada, quite famously, there was a moral rights case where an artist made a series of swans. And then this went into a mall, this like flying arc of swans, swans or geese or whatever it was, birds. Anyway, the mall wanted to celebrate Christmas. And so to celebrate Christmas, they went up and put ribbons on all of the birds. And the artist sued and said that violates my moral rights. You are making my my art into a piece of crass commercialism. And the court said, yep, that was improper. So moral rights get complicated. But the other thing is that, let's say Matt Colville puts out some sort of work and it's ORC licensed. I probably can't put Matt Colville's name on my stuff because, he's got that publicity right. The rules lawyer, who, by the way, has a great channel, you should check it out, says, I missed the part about DRM. So if a company uses Pathfinder 2 rules to make a video game, they can't prevent pirating of their game. Am I misunderstanding what DRM is? Theoretically, they would be able to make DRM that prevents pirating of the video game so long as you can still access the underpinning ORCable content. I don't know how you do that, though. That seems maybe you could end up then putting this out like where you publish that content in like a separate document. That might work. That's potentially workable. I see it's not like you give up copyright by not using DRM. Any viral nature seems minimal to layman me. We're going to explain why it's not minimal. And I'm happy with seeing the spirit behind the ORC enforced across the board. We will see how this goes. So, and what is ORC versus not ORC? So ORC, we went through what is ORC, but it includes like player character descriptions, classes, how to roll dice, mechanics, generation systems, items, spell descriptions, all of that kind of stuff. So lots of stuff there. All right. So to the extent possible, the licensor waives any right to collect royalties from you for the exercise of the license rights and use of the ORC content, whether directly or through a collecting society under voluntary or waivable statutory or compulsory licensing scheme. This is basically that some places have compulsory schemes for licensing. So this might include things like schools, where they might have compulsory licenses for photocopying, but also things like music societies, where they will actually send people around to bars to make sure that nobody's playing music at the bar without proper permission. So, yeah. I see. If you have product identity mixed in with ORC content in the same paragraphs, does this complicate things? A little bit. But yes. And so the viral thing, correct me if I'm wrong, means that if you adapt ORC content, then that becomes ORC content. The stuff that could be ORC content that isn't product identity will become ORC content if you use ORC content. So that's sort of how it's viral. It contaminates your work when you use this license that then you then have to license all of your work basically under the ORC terms. So that is where we're going to get into issues. Required notice. It is expressly conditioned on you including the notice statements described in subsections A to C in a reasonable manner. So you got to put a notice in, and they're going to give us some examples, but there's an ORC notice here that they tell us. Attribution notice. So statement based on reasonable good faith efforts that identifies each licensor or creator of the ORC content you used and any others designated to receive attribution, including all upstream licensors of ORC content upon which your adapted ORC content is based or derived from, in any reasonable manner so requested by such parties. So basically, you have to list everybody who is upstream of you, which will kind of provide these interesting trails of where the ORC content came from, which is interesting, right? That'll be interesting to see if this goes through. But you have to do it in a reasonable manner requested by the parties, which could also get interesting. Because if I was being a jerk-ass about this, I would start putting requirements in different sections in different places for different like let's say I release 10 products that are ORC content. Well, product number 1 will require it to be on the first page. Product number 2 will require it to be on the cover. Product number 3 will require it to be on the last page. Product number 4 will require it to be on the back cover. Product number 5 will require it. And so that could be a bit of a wrinkle, but I feel like trying to sue over the attribution notice might be interesting. But I think it's weird about any reasonable manner so requested by such parties. I would have just said any reasonable manner. But yeah, I may raise that. I'm going to send in a thing saying I've got some questions and some issues with that. I'm going to say, let's strike out that particular turn of phrase. So for the avoidance of doubt, both licensor and all parties similarly credited should be included in your attribution notice unless otherwise reasonably indicated by such parties. So, and a statement indicating how you wish to be reasonably credited with respect to the adapted ORC content, including by pseudonym if designated. So you can, I like this, that, I can ask that I be credited as role of law rather than as Ian Runkle. So, yeah. Somebody says, am I taking this on? I'm not suing them. I'm not anything like that. They've just put out a request for feedback, and I'm going to be feeding back. This is part of feeding back too, right? So this is something that is relevant. Product identity notice, a statement based on reasonable good faith efforts that identifies the elements of your product identity, if any, contained in the work in which you use the ORC content. So this is important because they basically just want you to categorize the things you are not giving up. Now, for avoidance of doubt, such designation neither limits your rights in your product identity nor limits any downstream licensees' use of the adapted ORC content. In the event of a conflict between your designation of product identity and the definition of ORC content, the definition shall control. So if you try to say that, hey, this spell description is product identity, then they're going to say, no, it's actually ORC content because spell descriptions are part of the definition of ORC content. So they give us a sample notice and they note that this is by way of example only. So it's just what it might look at. So that just sort of tells us this. You can see an example. Product identity elements in this product include, but may not be limited to, Hamlet, the Rotten State of Denmark, the Order of Rosencrantz and Guildenstern, and all elements designated as product identity under the ORC license, which is funny. I like the reference. So yes. What if the product identity predates ORC? They already covered that. They have said that, you can't claim product identity in something that's not yours, but if it is yours, then no problem. All right. Warranty and limitation of liability. You license the ORC content as is and as available and make no representations or warranties of any kind concerning the ORC content, whether express, implied, statutory, or other. This includes, without limitation, warranties of title, merchantability, fitness for a particular purpose, non-infringement, absence of latent or other defects, accuracy, or the presence or absence of errors, whether or not known or discoverable. So you can't sue the orc person if you end up using this somehow to build a shuttle and it blows up on launch. You also can't sue them if it turns out that their content is infringing copyright unless it's your copyright. So that's, just you may still have some legal liability as a result of that. Where disclaimers of warranties are not allowed in full or in part, this disclaimer may not apply to you. To the extent possible, in no event will the licensor be liable to you on any legal theory, including without limitation, negligence, or otherwise for direct, special, indirect, incidental, consequential, punitive, exemplary, or other losses, costs, expenses, or damages arising out of this ORC license or use of the ORC content, even if the licensor has been advised of the possibility of such losses, costs, expenses, or damages. They're really trying to cut down on litigation here, right? They're trying to make it so just because your content was ORC licensed out doesn't mean that downstream people can sue you. That's important. All right. Where a limitation of liability is not allowed in full or in part, this may not apply to you. And they say that this shall be interpreted in a manner that, to the extent possible, most closely approximates an absolute disclaimer and waiver of all liability. It doesn't say you can't use DRM, does it? Just that you can't sue people that break DRM for otherwise ORC purposes. It says you can't sue people who break DRM for otherwise ORC purposes, but also that you can't DRM your ORC content. And just getting a call here, but we will just make that go away. I'll have to call them back. All right, so other terms and conditions, termination and remedies. Now, this is interesting because they have noted that you can't get out of the ORC content, but there are some provisions here for termination. Your license to use the ORC content will terminate automatically if you fail to comply with the terms and conditions of the ORC license. Your license will be reinstated, effective as the date of termination, if you cure such violation on a going forward basis without the obligation to destroy inventory on hand within 60 days of your discovery of the violation, or if licensor waives such violation in writing. Which is going to be weird because the licensor probably won't actually be aware of that. No such termination shall affect, limit, or disrupt the rights of any licensor or downstream licensee of any ORC content under any ORC license. So if you get terminated under this, people who have used your content or want to use your content still can. Only the licensor and licensor's upstream licensors under this ORC license may bring enforcement action against you hereunder. This constitutes a limitation on licensor remedies with respect to the license grant in the ORC content hereunder. However, the ORC license neither limits licensor's remedies in any way with respect to licensor's product identity, nor does it limit licensor's right to offer the ORC content or product identity under separate terms or conditions. So let's break some of this down. If you violate this, they can then bring enforcement action against you. But the only people who can do that are specifically the upstream licensors, which will include whoever made the base game, which is going to be interesting, right? Because the base game maker may essentially have the big cards on enforcement on that, which is a little different than what they've said about we don't want a central enforcement organization. However, they basically said that the only thing that you can get out of this is to bring somebody into compliance. That's interesting, but I suspect that the reading of this may actually include the availability of some, of some financial remedies. But so this, this also says basically that they can still sue you for everything they meant to sue you for product identity, and they can also license things under separate terms. So they can make a different deal with somebody down this road. But even if they make a different deal with somebody downstream, the ORC potentials still apply. However, this is going to get real complicated. Can you mix licenses, ORC plus a licensable IP? Kind of. And this is going to be where you will need a lawyer if you want to wrangle this. That's where you're gonna need some counsel. Modifications. This ORC license may not be amended, superseded, modified, updated, repealed, revoked, or deauthorized. Deauthorized is, of course, a very specific shot at Wizards of the Coast. And I'm here for it. So, yeah, they basically said that once this license goes out, it is entirely permanent and unchangeable. So it's very important that they get it right. But we may end up seeing an ORC 2. That might happen. This ORC license does not and shall not be interpreted to reduce, limit, restrict, or impose conditions on any use of the ORC content that could lawfully be made without permission under this ORC license. This is important. You can do whatever you would have otherwise. So, yeah. To the extent possible, if any provision of this ORC license is deemed unenforceable, it shall automatically be reformed to the minimum extent necessary to make it enforceable. If the provision cannot be reformed, it shall be severed from this ORC license without affecting the enforceability of the remaining terms and conditions. So what is severability? Well, let's say you've got a contract and it's got 60 clauses, and each clause is a separate term. And it turns out that clause 39 is a bad clause. Like it's an unconscionable clause, or it's something else that can't be doing, that you can't be doing. So like 39 is, you agree that we can, harvest your body for meat, something that the courts will obviously find to be unenforceable. Well, if you don't have a severability clause in there, that bad clause throws out the whole contract. And there might be a whole bunch of good stuff in the contract. But the severability clause means that once you have that bad clause, that clause 39, that clause just gets thrown out, but the rest of the contract keeps going. So contracts almost always include these severability provisions because you don't want one bad term to throw out the entire agreement. So, although sometimes you do, sometimes you might, that if it's not going to be word for word applied, you want it to just be gone. All right. Nothing in the ORC license constitutes or may be interpreted as a limitation upon or waiver of any privileges or immunities that apply to the licensor or you, including from the legal processes of any jurisdiction or authority. I think that this one only is going to really matter if you happen to have diplomatic immunity. So, yeah. All right. So that's a whole lot of mouthful. And I suspect that a lot of you are watching this and going, what's the problem? This seems great. And fair enough. So what I did then is I went and purchased a product on DM's Guild, and we're going to skim through it too fast for you to read. But the reason why is because I have highlighted in this document all of the things that if you use the ORC license would then be sub-licensed as ORC content to the next person. So let's have a look at this. So this is the Vault of Magic book. It seems like a decent book. Some of the spells in it kind of suck, but there's good stuff here. It's like most third-party content. There's some great stuff in here. There's some crappy stuff in here. But let's look at the stuff that you would be licensing as ORC content to the next person down the stream. So not this picture, right? That wouldn't be ORC content. And not this picture, and not your sort of credit text and all of this stuff. But all of this stuff, not this picture, all of this, all of this, all of that, not the pictures, but all that. We see that we've got Lathander, that word doesn't get listed. All of this, all of that, all of this good stuff. All right, so if you're thinking, holy crap, that was everything, then you're correct. That was just about everything in that book was ORC content. And the thing is that if I've got the license to reproduce ORC content, well, they're selling this book for $3.99. And I think $3.99 is a perfectly reasonable price for the book. It's not, there's some good stuff in there. I don't feel bad about having bought this for $4 just to make this video. Although I may actually end up in the hole on this video, but that's perfectly fair. This is not a money-making channel, but so far I think I'm in the hole on this video, so we'll have to see if the ad revenue comes in. But let's also look at this book, which is Wizards of the Coast Spell Compendium. And this is actually volume 4 of 4. And this one is, this one goes from Squaring the Circle to Zone of Despair. It is entirely spell descriptions. So, I can flip it open and it's Talon Blade, which showed up somewhere, and Vitriolic Sphere, and Vocalize. And now this picture would not be ORC content. Like that, you wouldn't be required to sublicense. But everything else in here, all these spells, would be ORC content if I used ORC to make this book. Now, I've paid, I don't know, $25 for each of these volumes, and I actually think I got a pretty good deal because I still use these. I have been known to borrow spells from these and add them into my 5th edition games, right? But here's the problem. I paid $25 for this. The downstream guy can then say, okay, I am licensed. I'm using this as ORC content. I'm not copying the pictures. I'm not copying anything else, but every single spell description is going to be reproduced exactly as it is in this book, and it's going to go for 99 cents. And then that person's going to get screwed by the next guy who just does the same thing and says it's for free. Now, why would I write this book, right? Let's assume that instead of this being a compendium of all the spells that were written at the time, which is what this was, right? This was every spell that they'd put out in the game for the AD&D system. Let's say I sat down and wrote this, like literally thousands of spells. That's going to take a lot of work. That's going to take a ton of work. In fact, I'm going to be at this for months, literally months, and it's going to require a tremendous degree of skill. Why would I do that if I can't make $1 on this? Like, I couldn't even reliably sell this for $1 if I'm using the ORC license. And that's a really big problem because that kills the market. That kills the market dead. And that was the problem with the OGL license, right? The OGL license, one of the big problems that there was this whole thing of like, if I put my content out there, then Wizards can just steal it for the next edition, right? That was one thing people were really upset about. Well, that's baked into this. If I come up with a great spell, like a fantastic spell for Pathfinder, and it's, under this, then Paizo can just throw it into a supplement and I get nothing. And I see this, but Paizo puts all of its rules out for free on the SRD, and yet they still sell books. It would make every third party person need to allow an online reference, it seems, though. And Paizo can put the rules out for free on the SRD because Paizo is generating different content than a lot of people. Paizo stuff is going to include a lot of the setting details and so forth, which would be product identity. But for a lot of people, if you're just making, I bought something describing a new class. Well, that work in its entirety would be put out as ORC content at that point. And so somebody else could just take it and resell it. And why would they make that? So really your options are either to make entirely setting books. So, I mean, if you released like the next Dark Sun, you're fine because that setting book is going to be almost entirely product identity and therefore protected. If I want to release my campaign setting as a book and it's ORC, and I'm using the ORC license to do it, I'm probably fine because it's almost entirely product identity. But if I want to release, I'm working on a book about playing criminals in role-playing games. And tons of the good stuff in that, the stuff that is worth money that I would sell, is not product identity. It would be ORC content. And so somebody else could poach a large amount of that and just send it out. So this is a real problem because it kills the market. And that's what I'm worried about with this. I'm worried that if there's not these third-party creators who are willing or who are able to make a buck on it, that they're not going to, put out as much stuff. Those third-party content creators who actually make a living doing this won't be able to make a living doing it. If you look at like Kobold Press's Tome of Beasts, the vast majority of that, and it's a very successful product, right? But the vast majority of that would be not protectable if they use the ORC license. So this is, I think, a problem. And when you look at like the OGL was a bit of a one-sided grant. It was a grant from Wizards, the original OGL, not the crappy one that they tried to put in. It was basically a grant from Wizards to you, but it didn't require that additional aspect. So, and I see totally looks like a problem, not going to lie, but if I recall correctly, for Pathfinder 1, there was a thriving third-party community making content for Pathfinder 1 and putting their content out for others under the OGL 1.0A. Yep, and the OGL 1.0A was less like this, but, we'll have to see. I mean, there are some mechanisms that may help, and one of the mechanisms that is just social pressure. If I want to make a book right now and I want to use AI art, there's a bunch of people who won't buy it just because it includes the AI art. That is a social pressure. I suspect that if I was putting out books where somebody wrote something and they're selling it for $20, and I've just ripped off all the ORC content and I'm selling it for $2, there might be a lot of people just not willing to buy my $2 version just because screw me, because I'm, they don't like me. So that is a possibility. The other thing is Rules Lawyer was mentioning that people were putting their stuff out there under the OGL 1.0A. Sometimes people don't realize what they're sort of giving away too. So it gets to be a bit of a wrinkle on that. Now, this is not accidental. When we go back to looking at the, this is from the Axe again. We're sort of ending off where we started, where they say, why not Creative Commons? They note that Wizards used the attribution only one. And they say basically that unfortunately, when another company builds on their SRD, their innovations are trapped in their product and not automatically relicensed to the gaming community. This effectively kills the virtuous circle that open source communities are built on. Well, sure, but that's kind of the point. And I don't know that virtuous circle is going to work as well, where we've got this, where we've got a very different kind of community, because I know people who are heavily involved in open source communities, but it's usually not their day job, or where it is, they've got a day job. I mean, I know some people who have earned a living being like, I run this project and people donate to me, but I don't know if there's enough out there for most of these creators to earn a living doing that, especially because a lot of these products are really made for beer money. Not like, this is my career. The big lucky winners of this will become the career money people. But most people, it's going to be, hey, I sold a book. It did really well. I'm going to buy like some more miniatures and some more gaming stuff and that kind of thing. That's the kind of profit margins we're looking at here. And so that's really what we're, talking about. So, and the other thing is that a lot of the people who do the open source stuff get recognition that helps them get jobs. So like, hey, I contributed all this stuff to this open source project. Now I might get hired at Google, which is great. Google probably pays big money. Unfortunately, if you're getting hired at Wizards of the Coast based on the stuff there, you're probably not making huge money. It's probably not that sort of situation. I don't know that this virtuous circle concept is going to work as well. I suspect what it'll mean instead is just people not making certain kinds of content, which is a problem, right? As I said, I don't feel upset about having paid the money for that vault of magic. It seems like a decent project or product to me, but that doesn't mean, so I'm concerned if nobody wants to make those things and instead we get 600 million settings because that's what you can protect. So I'm raising this concern now because they're still in the, they're still in the design phase. And I'm going to try to give this back as feedback and try to suggest that maybe they should remove this because, I would not want to make content under these restrictions. I would actually probably still create content, but I would not touch the ORC license. So I guess I still have to do that video about how to sort of do content in a setting without running afoul of these licensing rules and how to sort of DOGL and deorc your content. So that's kind of my concern with this one at this point. I really like the idea. I really like the fundamental basis. I think that the only big problem that they have in this is this attempt to impose this virtuous circle that I don't think is going to work. So let me sort of get to some of the starred and a couple of super chats here. Akiruki, thank you very much for the book fund donation. Much appreciated. Brentwood Chic, to offset the cost of the book. Thank you very much. Rules Lawyer, yeah, I can see consumers being like, screw that guy, lol. Sometimes, I mean, there is consumer pressures like that, but there's also going to be consumers who just say, you know what? No, we're just going to get the product. So it depends. But by the way, I'll try to share this concern on the ORC Discord. I just joined the ORC Discord myself. I'm hoping I can sort of raise some of these concerns there as well. Because yeah, I don't want to be like Debbie Downer on this one. I think that what they're trying to do is a really good idea. I think it's a great concept, but I'm just concerned about how this works out. So anyway, we'll see, but I'm just gonna keep talking about this sort of thing and keep sort of going on about stuff. Also, if you're new here and are not familiar, I've been doing I'm running a sort of giveaway here, and that's because I ended up accidentally making a little bit of money on this channel, which was kind of not intended. And that was during the whole Wizards of the Coast OGL debacle. So because of that, I decided I was going to give some of that back. And so part of the way I'm doing that is with a fun giveaway, which is I am doing a Win Gimlet's Gold, although it's gold with an asterisk, because it's actually 10 silver coins that I'm giving away, which and under D&D terms equals a gold, right? Actual gold was too expensive, like way too expensive, and the too expensive starts triggering all sorts of legal headaches. So the reason why I can offer this in Quebec and across across the US is because the value isn't high enough to start triggering all those really nasty obligations. But yeah, these are silver coins. They are pure silver, so 949 silver, so real silver coins. And yeah, there are 10 of them. And if you can, so check out, there's a video about that. Check that out. You can see how, what you have to do in order to win. It's going to be a challenge. I can tell you, I don't think there's enough clues out there to win yet, but I'm going to keep monitoring to see if somebody gets the full combination. And once somebody does, they'll get a shipment of 10 silver pieces there. Somebody saying, have they got the queen on them? They do, actually. So they do indeed have the queen on them. So check out that video. Keep watching because I'm gonna, this is kind of a fun puzzle, and I thought it was kind of a neat way to go. So check it out. Those I will continue to drop hints as we go. There may have been a hint in this video, very cunningly placed, and yeah. The other thing is, what is it? Check out the what is it? The terms and conditions. I had fun writing them. When you've got a lawyer and a sense of humor, then yes. Those are the silver maple leaves. Yes. So they are they're good stuff. They have a good recognition. We've got Uncivil in the chat saying, Ian, come back. I'm sorry. I got work to do up here in Canada, but it was good seeing you. So yeah, that's about sort of the long and short of this one. I'll wrap it up here, but yeah, as I said, I think this is a good license. Somebody asked, what would I change? And really, I think that this is fairly easy to fix. I guess I can talk about how I'd fix that fairly quickly, which is just that I would remove clause 2B. We can solve a ton of it just by removing this bit and some related clauses, but 2B would be sort of the critical one, is the grant of adapted ORC content. If you take that out, this becomes an amazing thing, and I really like this once you take out that stuff. So that's really the fix there. So Claude Simeon saying, I didn't enter the contest yet because I haven't figured out any of the clues. Keep trying, because that'll be useful. Yep, very popular worldwide for collecting in silver quality. Yep. I feel like maybe I shouldn't be putting my fingerprints on it, but it is what it is. But yep, I will see you guys next time. And thank you for joining me. This was a fun little rundown. So, and I think I only have the one outro, so I'll just run the outro that I use for Runkle of the Bailey, because hey, it works here too.